On February 14, 2022, a Canadian Prime Minister invoked an emergency law that had never been used in 34 years. Within hours, 206 bank accounts were frozen, holding $7.8 million. One of them allegedly belonged to a woman who donated $50. Now hold this number because it pays off later. 30 years. 0 successful creditor recoveries in one specific jurisdiction on Earth. Here is what nobody teaches about whose money the system was actually built to protect. On February 14, 2022, Justin Trudeau invoked the 1988 Emergencies Act. The law had been on the books for 34 years and had never once been used. Within hours, 206 bank accounts linked to convoy organizers were frozen. Total assets paralyzed, $7.8 million. No charges, no conviction, no advance notice. One of those accounts allegedly belonged to a woman in British Columbia who donated $50 through a legal crowdfunding platform. Hold a second number in your mind. 30 years. 0 successful creditor recoveries in one specific jurisdiction on this planet. That number pays off later. She drove no truck. She attended no protest. She gave $50 to a cause she believed in through a platform that was fully legal at the time of donation. 4 days later, her rent was due. Her account was frozen. A member of parliament from British Columbia raised her case publicly. The government's official response? Possible, but unlikely. She was never named. She was never charged. She never received a direct explanation. Sit with this for a moment. The freeze is not a hypothetical tool reserved for terrorists and oligarchs. It has already been deployed against a $50 donor whose name we will never know. Here is the part that should stop you. The freeze is not the start of an investigation. It is one of the final steps. The questions were asked and answered months ago without you by your bank records, not by your testimony. The Federal Trade Commission routinely seeks asset freezes ex parte. Here is exactly what that means. The defendant is not present. The defendant is not notified. The court signs the order before you know there is a case. Civil asset forfeiture requires only a 51% probability that the money is fraud proceeds. Not beyond reasonable doubt. Not a conviction, not even a charge. 51% and the burden flips. Now you have to prove you deserve your own money back. Now cut to what the wealthy were doing the same week of the convoy freeze. Nothing. No scramble. No panic. No rerouting of funds. No frantic calls to Zurich or Singapore. The common belief is that offshore wealth protection is for tax cheats, drug money, and Cayman Islands criminals in linen suits. The truth is darker. The most bulletproof structures on Earth are openly legal, fully IRS disclosed, and used predominantly by neurosurgeons, business owners, and real estate developers. They did not need to react that week. They had reacted 20 years earlier. Which brings us to a nation of 17,000 people in the South Pacific. The Cook Islands. In the early 1980s, this tiny country made a sovereign decision. It would write its laws to become legally impenetrable to foreign courts. The Cook Islands International Trusts Act erected 4 barriers. Barrier 1. The Cook Islands does not recognize U.S. court judgments. Period. Barrier 2. A creditor must prove fraudulent transfer beyond a reasonable doubt. The criminal standard. Barrier 3. Before filing, that creditor must post a bond of at least $100,000 with the Cook Islands court. Lose, and the bond is forfeited. Barrier 4. A statute of limitations of 1 to 2 years on transfer challenges. This is not a tax loophole. This is financial architecture as foreign policy. In 1998, the Federal Trade Commission tested the fortress. The case is FTC v. Affordable Media. The defendants were a husband and wife named Anderson. A federal judge ordered them to repatriate their offshore assets. They said they could not. The trustee in the Cook Islands had legal control. The judge did not believe them. He held them in civil contempt and put them in jail. The money stayed in Avarua. They stayed behind bars. Eventually, a deal was struck. They were freed only after agreeing to remove their offshore trustee and replace it with a corporation formed by the FTC itself. Were they victims of their own clever structure or masterminds who gamed the system? The court never definitively answered. The money never came home on the court's terms. Here is the mechanism nobody explains correctly. An offshore account by itself is not enough. The law knows this. A U.S. court can order the account holder to repatriate the funds and hold them in contempt for refusing. Full protection requires pairing the account with an offshore trust that legally removes the individual's control. This is the actual asset protection strategy, not a numbered Swiss account in a spy film. The wealthy do not hide the money. They surrender control of it on paper. They sign documents that make it legally impossible for them to bring the money back, even if a federal judge demands it. That impossibility is the lock. The trust is the lock, not the account. Now here's the price of the door. Setup costs run $20,000 to $25,000. Annual maintenance, $5,000 to $8,000. The threshold where the economics work begins around $1 million in total assets, or $500,000 in liquid non-exempt wealth. As one asset protection attorney put it bluntly, if you have $1 million and you are sued for $5 million, that could be devastating to you. The door is not secret. It is not hidden in some Caribbean back room. It is listed on law firm websites. It accepts wire transfers. It is priced. Justice, it turns out, has a price point. Here is the scale. Over $30 trillion in private wealth currently sits in offshore jurisdictions worldwide. An estimated $3.2 trillion has moved through offshore trusts in the last decade alone. The Panama Papers, the Paradise Papers, the Pandora Papers named Russian oligarchs, sitting world leaders, billionaires, celebrities, and yes, Cook Islands trusts featured prominently in all three. Almost none of it was illegal. The IRS knows. The IRS has always known. Trust holders file the required disclosures. Creditors know nothing. Business competitors know nothing. The public knows nothing. The wealthy did not break the rules. They wrote different ones. Here is the full picture. There are two financial systems operating inside the same country. In one system, the rules apply to you. Frozen accounts, the 51% standard. Ex parte orders signed without your knowledge. No carve-out for legal fees. No carve-out for rent. No carve-out for the mortgage on the house your kids sleep in. In the other system, the rules were designed around you. A criminal burden of proof, a $100,000 filing bond, a trustee in Avarua who simply declines the U.S. court's order and faces no personal consequence. The same federal tools that froze a $50 donor's checking account in February 2022 cannot touch a single dollar inside a properly constructed Cook Islands trust. Not with a court order, not with FBI involvement, not with the full weight of the FTC. Return to the woman in British Columbia. Her account is still frozen. Somewhere that same week, a trustee in Avarua filed nothing, answered to no one, and quietly protected someone whose name you will never read in a newspaper. The story that the system protects you is true for one group of people. It was never meant to protect the other. Knowing the mechanism exists is the first step. The architecture is legal. The disclosure is mandatory. The door is priced, and it is open to anyone who can afford to walk through it. The only question that remains is which side of the system you were standing on when you found out it had two.